that applies in the opposite direction too. For, just because some people have royalties or are getting money, that they need to be represented and the rest of the county doesn't.
Yeah, I'm sure the people that.
Well, I'm not saying that. I'm just suggesting to you that it's not, just because you believe it to be a certain way, that everyone in the county.
Well, I would just like to go on record.
I think that's a good one.
I am the royalty owner for the land that's in question that Mr. Hastings and I have been in court over. And I don't.
I realize that.
Well,
need to
and
bring
Ms.
it up.
Before you
There
finish
comes
that.
a point where the right to earn money does not overrule the right to protection of life and safety.
Let me just clarify, and I think you probably can move on to this debate. We're not going to solve these problems here tonight. I think we can all agree on that. But all of the royalty owners on this particular lease don't feel the same way as Mrs. Hunt. So, I mean, you're speaking for yourself, and I appreciate that, and I appreciate your position, but your fellow royalty owners may not feel the same way as you on that particular issue. And there are various issues here. I mean, we're obviously talking about industry and its residents here tonight, but again, we're not going to solve these problems tonight or probably tomorrow.
Did we address already? I'm confused after all this time. There on page 29, there was a section about.
You have something, Dan?
Well, I just wanted to comment that keep in mind what you're saying here is going to apply to everybody, folks. You may live in the floodway, you may want to put a load of gravel in your driveway. If you put a load of gravel in your driveway with zero tolerance, you're in violation.
Well, then let's get rid
It's
of
going to cut both ways. It's going to cut both ways.
They got lots of gravel.
It's
I
going to cut
understand
both
that it
ways,
works
folks.
both ways.
And there's something else to
It's
consider.
the same as the industry.
Even though other landowners, if something's taking part and they're wanting everyone notified, the person has rights. And sometimes your rights ends where mine begins, or mine ends where yours begins. You can't control everybody's.
That's a true statement.
Did you already, someone address the fact that in this one paragraph on page 29, that the administrator shall require the applicant to demonstrate through engineering reports rather than may require?
That's not been discussed, but I see your point.
I think
The
that-
commission will consider it.
Okay.
I would just add, though, that if that's the case, it's going to be, it should be all applicants are treated the
Yes.
same on that issue. And
Sure.
that could be an expensive process for someone who just wants to put a load of gravel in their yard. And I would urge the commission not to adopt that standard.
Any field, anything you place there, anything, you place there, one truckload of gravel from Johnny Davis, that's going to apply just the same.
A floodway, yes.
Unless it's properly tethered to a concrete wall.
Only after the floodplain study says it's okay.
But here's the problem, you know, and that's what, they're trying to bring some sense to the process, and that is this, that if it applies to you, then you have to go out and get a floodplain survey. It's gonna cost you $5, $6, $7, $8, $9,000, $10,000 to have that done, to get permission to do that. So some of these things you're being, you want to be.
I don't think anyone should just do that if they're just putting gravel in the driveway, but if you're
Well, that's
doing
what-
But you
something,
can't draw, where do you draw the line? It's a slippery slope.
if you're doing a development that's gonna take up 5, 6, or 7 acres of the floodplain, then it's important to know where the floodway is.
Big difference, significant harm.
Oh, no,
Common sense.
I mean,
No, no,
They should be able
You're
to
leaving out a big fact.
If you've got an ordinance on record, what goes for one goes for all. It's
But
written for
size
everybody.
Yes.
Well,
I
but it's, the only thing I'll say to you, sir, is it's not currently defined in terms of size.
Should be.
So there should be a
The
definition.
more concise we are with this, the less we leave it open for all these lawsuits, and that's what this should be all about.
Size matters. In floodplain.
I believe you did, I'm sorry, I can't do this. I believe you did say on page 30, someone's already addressed the issue that the CLOMR, that's a mandatory thing. That it's not going to be left up to just if the floodplain administrator should ask.
And I don't
think we've discussed that.
well,
Actually, it
we
was.
discussed a CLOMAR. You haven't discussed that it's, just required. my comments and suggestions are kind of in line with probably what you're thinking is, under what criteria are those things are going to take place? I mean, there's no rhyme or reason to why Dan may say you need one or don't need one.
Well, I would respectfully suggest we put that forth to Mr. Sneed then, because it was my understanding, if you're going to majorly alter the floodplain, you have to get this certified letter from FEMA. And it should be done before any of the construction begins. So I don't think it should be an option. I think it should be a mandatory thing. That's my opinion. So I put it in there.
Yep, it's it, we got it.
They can either take it or not. Okay. Page 31, the setback. It is not compliant with the new state law. Paragraph H, which has to do with the flood protection setback. The way it's worded right now, it says that you only have to be 50 feet. Or if the width of the waterway is less, then you can do the smaller amount.
Yeah, that doesn't surprise me because the ordinance was written so long ago that if there's been a change in state law.
Well,
Do you have the state law citation, the code section?
the new minimum is 100 feet.
Well, I understand you're saying that, but you have the West Virginia code section so I can check it?
Yes,
Yeah.
22,
Yep.
6A12,
6A12,
B.
capital B?
No, small b in parentheses.
Thank you very much.
No well pad will be prepared within 100 feet.
Thank you very much, Mr. Foster.
And I also suggest that because with drilling,
Is it in the same section?
I also suggest because the new House bill that has to do with drilling, there are different measurements depending upon the type of well or development that's being put in. So I also suggest that you put a sentence in there that says the setbacks for the oil and gas developments must comply with the state law, because they do have different regulations, correct, sir?
I mean, I don't think it needs to be in there because it has to apply, we can't get a permit if it doesn't.
That should be in.
And there are ways for, as I understand it, some of those setback provisions to be waived by a surface owner. So, for example, if you have a small stream in your house, and there's a setback provision that you still want a well, you could waive that provision under the DEP, so that option's still there in that process. But the DEP controls those issues.
Okay. I guess that's up to the
Do they
commission.
have a right to appeal? Anything? DEP doesn't have a right to appeal permits. I suggest we put it in the local ordinance because that makes it,
I think it's more
DEP
beneficial
has a
for
policy
us.
where I have it in writing that they do not afford landowners the right to appeal a permit when it's issued.
Isn't there language in the back?
If we don't put the language in this, and they issue the permit in error, we don't have an appeal process.
It says what?
You got 500 state rules in law. I think there's language in the back of this, this is helpful, that suggests that you have to comply with other, somewhere in here, I think it says you have to comply with other state laws. That would probably cover that. I'm not 100% sure. But I think that there's a provision that says you must comply with all other state rules and regulations.
Any problem with putting it in there? On a local level?
I mean, you're going to go through every rule that we also have to comply with and put it in here.
Yeah, because
And that's the slippery slope.
I'm just wondering, you said, well, DEP's got it covered, but the problem with